At the same time, let us go through some of the provisions of the Indian Evidence Act with regard to the protection of witness. Protection against a compulsion to give evidence. Section 132 speaks, it is regarding the compulsion to give the evidence, but no witness will be compelled to give the evidence, and this is the protection available to them. And this particular section 132 of the Indian Evidence Act is a reproduction of the English law as to privilege of a witness from being compelled to answer the questions. So, the Supreme Court of India in Yellavarthi Pedatha Reddy versus Yellavarada Reddy AR 1929 Matters 236, the court observed that in order to avail oneself of the protection given, he must bring himself within the proviso. In other words, he should be compelled to answer the question. The compulsion contemplated in section 132 is something more than being put into the box and being sworn to give evidence. The compulsion may be expressed or implied. It is not necessary that the compulsion must be in any set form of words, or that the asking for protection should be in a particular form. If the witness is made to understand that he must answer all questions without expression, it should amount to compulsion. In all cases, it is the question of fact whether there was or was not compulsion. So, also if you will go through the section 138 of the Indian Evidence Act with regard to examination of witness, this particular section prescribes 3 types of examinations: examination in chief, cross examination and re-examination. So, for the cross examination is concerned, the objective of this particular cross examination is to ascertainment of truth, to find out the truth and importance of the right of cross examination of the accused. So, for the case law is concerned, on this particular section, Nandaram Khemraj versus State of MP 1995 CRLJ 1270, Supreme Court in this particular case observed that the weapon of cross examination is a powerful weapon by which the defense can separate a truth from falsehood, piercing through the evidence given by the witness who has been examined in examination chief. By the process of cross examination, the defense can test the evidence of a witness on anvil of truth. So, as I was describing the Nandakumar Khemraj versus State of MP, here in this particular case, the court held that by the process of cross examination, the defense can test the evidence of a witness on anvil of truth. But there are certain exceptions, where the exception is where the cross examination is not possible, then the previous deposition of a witness can be considered relevant in subsequent proceedings. Then let us go through the provisions under section 148 of the Indian Evidence Act. Proper and improper questions. This particular provision says that if any questions relates to matter which is not relevant to the suit or proceedings under hearing, except it affects the credit of a witness by injuring his character, then it empowers the court to decide when such questions shall be asked and when such witness be compelled to answer it. The section itself has given out the consideration in form of 3 clauses to decide whether a question proposed to be asked is proper question or improper question. It is pertinent to go through the section 149 of the Indian Evidence Act, which speaks regarding impeaching the credit of witness. A question intended to impeach the credit of witness ought not to be asked. Any questions which impeaches the credit of witness should not be asked to the witness, but there are exceptions. The exception is the person asking it has reasonable grounds for thinking that the imputation which it conveys is well founded. Then in this situation, the questions can be asked though it is impeaching the credit of the witness. Then section 150 of the Indian Evidence Act says that penalty for reckless cross examination. When the witness comes to the honorable court and is being cross examined by the defense advocate, the reckless cross examination penalty will be imposed. If the court was of the opinion that the questions were asked without reasonable grounds, it is held in Prakash versus State of Maharashtra 1975, Criminal Law Journal 1297. Even section 151 of the Indian Evidence Act, which speaks indecent and scandalous questions, this particular provision empowers the court to forbid the putting of any questions which is indecent or scandalous. Exception: provided it does not relate to fact in issue or to matters necessary to be known in order to determine whether or not the facts in issue existed. In this context, I would like to highlight a case law Baburao Patel versus Bal Thackeray, that the specifically the indecent and scandalous questions should not be asked to the witness at the time of examination. Even section 152 of the Indian Evidence Act is very important to highlight in this context, and is very related to this particular topic. This particular section 152 of Evidence Act empowers the court to forbid any question which appears to be intended to insult or annoy or needlessly offensive in form. If any questions which is offensive in form or which intended to insult or annoy the witness, that type of question should not be asked. There is a prohibition prescribed under section 152 of the Indian Evidence Act. So, section 149 to 152 together with section 148 NT were intended to protect a witness against improper cross examination, a protection which is often very much required. These are the laws prescribed in India, the general laws. Specifically, if we will go through the special laws in India, specifically where the witness protection has been prescribed, that is the specific offences where witness protection is granted, specifically in terrorist acts and organized crimes. The first one is West Bengal Act of 1932, that is the Bengal Suppression of Terrorist Outrages Act 1932. Section 31 speaks exclusion of person or public from precincts of the court, when at the time of a trial of a particular case which is related with the terrorist act or the organized crime, the persons or public will be excluded and they will not be allowed to in the precincts of the court. But there are certain exceptions. If a certificate of a public prosecutor or advocate general is given with reasons, or where the interest of the public peace and safety is involved, where peace or safety of witnesses is involved, then the persons or public will be allowed in the court on the application. So, also the second one, special law, that is the TADA of 1985 and TADA of 1987, protection of identity. Section 13 speaks regarding the protection, especially in terrorist acts or the cases related with the crime which is the terrorist or organized crime. There the protection of identity has been prescribed, and the identity of the witnesses, those who are giving the evidence to the honorable court, will not be disclosed, and if any identity or address or the testimony of the witnesses are disclosed or published, they will be punished. This is the protection given under this particular act. Then the Terrorist and Disruptive Activities Prevention Act 1987. Here the mandatory provision to hold proceedings in camera when the case is related with the terrorism or the crime which is a group crime, and especially the special court is empowered to hold a proceedings in camera under section 16 subsection 3D of this particular act. The validity of section 16 was challenged in Kartar Singh versus State of Punjab in 1994, 3 SCC 569. The honorable court held that the constitutional validity of section 6 is constitutionally valid. Then Potter 2002, that has been repealed in 2004. Then the Unlawful Activities Prevention Amendment Act 2004 amended in 21 September 2004. The provisions of Juvenile Care and Protection of Children Act 2000. Here also section 21 of this act clearly speaks regarding restriction for publications. The section it says that the name and identity or address of the witnesses, those who are giving the evidence before the honorable court, are not to be published in any newspaper, and it should not be disclosed to anyone. This is the restriction imposed on them. The section also speaks regarding an exception. If the interest of the juvenile is included, then the testimony can be disclosed. Then the special statute, that is the National Investigation Agency Act 2008. Here the section 17 speaks regarding protection of witness. and proceedings will be conducted in camera. And the section also says that keeping identity and address of the witness secret, where the special court is empowered to comply the section 17 with regard to the protection of witness.